verified, secure real property transaction.
Good afternoon once again. Welcome back to the Senate Committee on Government Operations meeting of Tuesday, February 17th, 2026. And our next item up for consideration is S-192, which is an act relating to municipal authority to compel the cleaning of or repairs of premises. We have both the sponsor of the bill, Senator Clarkson, and Legislative Counsel Tucker Anderson. So I don't know, do you have a time constraint of any sort?
I do not.
So why don't we have Allison go through her reasons for this and sort of kind of tee it up.
Well, the reason for this is close to Tanya and mine and Tucker's heart, which is the Springfield Charter. And the Springfield Charter enabled this opportunity. Tucker's just working. Enabled the city of Springfield to address several properties that were blighted, vacant, non-compliant, and a mess. Because for a variety of reasons, it affects our grand list, it affects our neighborhood morale, it affects the health and safety of the community. And other towns have approached and asked if we could roll it out statewide. So that is that's what this does. It expands, it takes the opportunity we created in the Springfield Charter and enables it for all towns to do. And
How long ago did we do the Springfield Charter?
From 2022.
she was sold in the house.
All right.
Yes. I want to be clear that we share thoughts on this issue, but they don't necessarily align.
Which is often the case.
So I would have been in this committee in
When I
22.
dealt with this.
I don't remember it, but I'm sure.
I do.
Did I vote? Do you remember which way I voted?
I
Supported it. We can go back and look. It was the
Okay.
Springfield Charter.
All right. And this bill,
This piece, this pulls
92
this piece out.
mirrored on that.
Yes, and enables it for all towns.
Okay.
I mean, Tucker will tell us what it enables.
If you'd like to join us at the table, sir.
Good afternoon, Tucker Anderson, Legislative Counsel, here to talk about S-192. Up front for the artificial intelligence that transcribes all of these meetings. When Senator Clarkson said that it was near and dear to my heart, she was talking about the tension between the two GovOps committees.
Correct.
It is a tremendous amount of work for Legislative Counsel and aged me several years in the process of just a few weeks of negotiation.
This is correct. Although I will point out that you do not yet have a white hair on your head.
It's a wonderful gift. Right from the fountain of youth on my grandfather's farm when I was a child. I am truly everlasting.
And was that farm here or in the mother country?
The mother country of Sandusfield, Massachusetts. In a spring well out in the woods that my grandfather dug when he was
Your age.
my age or younger.
Right, exactly.
Okay.
So on that note.
On that note, Senator Clarkson gave you some of the background. S-192 is modeled off of existing authority in the town of Springfield Charter with a few modifications that I can point out as we go along. If you would like to take a look at the Springfield Charter provisions at some point, I can share them with you. The language in the Springfield Charter is a bit more general than what you see here. There's one operative provision within S-192. But don't get too excited because even though it's basically one page of text, it's going to take a while to tease out some of the legal issues that are raised by the authority that's being granted here. So to start, this is the first time this committee has taken a look this session at 24 VSA section 2291. These are the enumerated police powers of municipalities. This is the consolidated list of power, specifically legislative power, that the General Assembly has given to any municipal corporation in the state. So the way that 2291 operates is that by passage of any bill granting authority within this section, you have already delegated authority to all municipal corporations in the state to adopt an ordinance on this subject. So this doesn't mandate that this would take place in a municipality, but you have affirmatively granted them the ability to adopt an ordinance governing the subject. Now, the authority, some of the authority in here to compel the cleaning or repair of a premises already exists in 2291. This expands that authority. So within subdivision 13 in 2291, the top of page 2. First, some language is moved around here. States that to establish, there's the authority to establish health and safety standards for premises within the municipality. And to compel the cleaning or repair of any premises that the legislative body determines to be vacant, blighted, or damaging to the general appearance of the municipality. Now, these terms within the four corners of this delegation of authority are not defined. And one of the things that I point out every time we talk about any piece of law affecting property is that property law, by and large, is backed by centuries of common law. Decisions from courts, not only in the United States, but our predecessors in England. Okay. British common law also applies here and how these things are. So, if the committee pursues this, certainly you may want to hear testimony about what would qualify as vacant or blighted. And since you are granting the entirety of your authority around these two subjects, how could a municipal corporation define those two terms within the understanding of both statute and common law? Finally, damaging to the general appearance of the municipality. That is part of the authority that you granted the town of Springfield in their charter. All right.
Senator Bielanski.
I believe that was primary part of the tension that you may recall, Tucker, was that language. But I also, we heard from a different legislative council attorney on a different issue, but it was around the definition of vacant and the constitutionality of taking over someone's property and that sort of squishy idea of what is vacant.
Yes, and when we're done walking through the language, one of the background issues that I'll talk to you about is takings and how takings analysis will have to be conducted either before this moves or afterwards by the individual municipal corporations that are adopting ordinances. And Senator White is already so familiar with this from the discussion about trails, but due to some recent US Supreme Court decisions, you could have an immediate regulatory taking just from granting the authority of a state or municipal officer to enter a property where it is not found in the background common law purposes for which a state governmental actor would enter property in the first place. Because you're taking away the right of the property owner to exclude, which is part of the bundle of rights that all property owners hold.
Senator Morley.
On that 13A1, legislative body determines to be vacant, blighted. The hopes these discussed vacant. Damaging to the general appearance of the municipality. I don't know how anyone. What does that mean?
Does that mean I don't like your red door?
Exactly.
In order to avoid other constitutional obstacles, the municipal corporation would likely have to define the standards for each of these terms, and then in the enforcement of the ordinance, determine whether the individual property has violated whatever those standards are. You do not have to delegate this level of authority and discretion to the municipal corporations. You can certainly define all of these terms within the four corners of the bill if that's how you choose to proceed.
Right. Yeah. That one phrase has got a lot of stuff in it.
It does.
Once you unpack vacant, blighted, or damaging to the general appearance.
You have not talked about the term blighted. It
No, we
appears in one other body of law in Vermont law.
We already have.
Urban renewal
Yeah.
statutes. But the background definition of what constitutes blighted state by state varies pretty significantly. So I can provide you with.
I think Senator White has to first.
Yeah, thank you, Mr. Chair. So can I just understand? So yeah, we spent a lot of time on trails in this conversation. And what's confusing me about this language is I thought you couldn't go onto a property as a municipality for really like any kind of maintenance purposes. Like, wasn't that the whole debate? Was even if it was legally owned by the town already in some convoluted ancient roads way, they couldn't maintain
Without
to a
going,
certain degree. So I'm just wondering, we had a long conversation in Senate Transportation about this, because even the maintenance of a trail using a chainsaw to move a tree was considered potentially a problem. And I feel like what makes me worried is, okay, if someone cuts down a tree on a property, even, if it's vacant or blade because it's falling into it, like we had a lot of issues with doing that on not land that someone was living on. So I guess if you could just tell me a little bit more about, there was like a threshold of when you were damaging the property.
But the trails have the underlying ownership.
So this
The
has even
underlying
less.
road is
Mhm.
different.
Yeah. Sorry, that's
It's
all
underlying owned
I'm
by the
getting.
we're gonna have so much fun here. So to start parsing some of this out, there are within the police power of the state, there are definitely reasons and the ability that state actors, municipal actors can enter property.
Okay,
Okay, so just as kind of background information, typically it's to prevent injuries, hazards to the public. So if you were to take Vermont's tree warden statutes as an example, the tree wardens have authority to trim trees that would cause hazards to the public or hazards to a public way, right? So within a certain distance of the town road, the tree warden has authority to identify a diseased or hazardous tree and to cut it down. Leave the lumber for the property owner, because otherwise you would be taking the property. But you have the ability to enter the property to do that. Similarly, you could have criminal enforcement under a warrant entering property there. Depending on the use of the property and the type of license that might be associated with it, you could have conditions on a license, constitutional conditions. We'll talk about unconstitutional conditions on licenses at a different time, to enter property for purposes of inspection. An example would be liquor licenses. So lots of decisions around the time immediately following Prohibition where the state control agencies entered property to check inventories of alcoholic beverages, and it was a condition of the license issued to those particular businesses that the state be able to, in order to protect the public, adequately ensure that the inventories kept at those licensed establishments were accurate. So just a few examples. You are correct, Senator Clarkson, that in the context of trails, the discussion was about the fact that the municipal corporations already own an interest in the properties. The debate was whether the bill at that time was granting additional rights to the municipal corporation that they did not hold under the terms of their easement. And if they were granted those rights, would it be automatically a taking from the underlying fee simple property that must be compensated in order to meet constitutional requirements? Now here, the existing delegation of municipal corporations allows them to enter the property to compel cleaning or repair under certain circumstances where there might be injury to other properties in the vicinity or where it creates a hazard to the health and safety of the public.
Right.
Similar issues here.
so
Senator, I'm sorry.
could I ask, so then is there a chance with this bill that the town would ultimately have to compensate if there was something that was changed, that was,
If a court were to find that a taking
had
took
to,
place, yes.
okay, that's a whole nother area.
Triolsky.
So I've got two things. We're gonna circle back to the tree warden. The tree warden can't cut the tree down because they think it's ugly or because it doesn't match the rest of the trees in town. Correct?
There is some interesting language in the Title 19 provisions relating to tree wardens about offensive material is what's used. And there was a question at the time about whether that included like plants that just don't look good. Like purple loosestrife is on your property and the state is going to come in and cut down everything within 10 feet of the road near your house.
And was that deemed to be acceptable?
It certainly passed, and I can point you to those provisions.
Right.
So I don't know if it's ever been attempted or challenged.
Okay. My other question is around, you had mentioned instances in which the state might enter to prevent injury.
Mhm.
How do we define injury? Is that a physical injury? Is that you hurt my feelings? Is that makes my eyes bleed because I think it's ugly?
It could,
The lab.
I believe it's economic, with Springfield, it was both economic and physical,
Another point of tension.
but one that's very real.
Yeah. This was a long.
So there's
This is gonna be a
two injuries we're talking about here.
tough.
Fire.
Oh, fine.
Fire is the best example that I can give you. If you had a building that did not meet the fire code and was from a building inspector or fire safety inspector's perspective, dangerous to all of the other buildings about it because it poses a serious risk of fire, the state could enter to abate whatever that risk is. And you'll know if you were to go through Title 24 that a lot of the provisions where this authority is delegated to municipalities, the fire inspector, fire chief is one of the parties who can exercise some of this authority.
Okay, and but that makes perfect sense. Fire, you're protecting the whole town. We've heard stories throughout history of
Mhm.
big fires, yes.
A whole town.
And we don't want that. I guess, when we start thinking about injury without sort of physical injury or that threat of, like economic injury, does that mean that I can call the town and be like, hey, this poor person next to me is bringing down my property value, go do something about it? Like, what does that mean?
This exact line of questioning came up in the context of the Springfield Charter.
I remember.
The answer is within the four corners of the proposal here, you're delegating authority. That could certainly be part of what municipality adopts under this. If you want to constrain it, you may do so. And I can draft you language that would prevent that from happening. So the language that passed out of House GovOps, I recall, was very specific to attach physical injury, the risk of physical injury as part of, the constraints around this authority.
And believe you might have drafted that amendment for me when I was on House Bill Ops, so.
Yes, and I believe the example that you used and Representative Hickey doubled down on was porches that have refrigerators. I have an old refrigerator or a dishwasher on my front porch in town, I'll pick it up, take it away and hand me a bill.
But
I lose so many.
This was a deeply contested thing.
Girl, I was there. I forgot that example though. That was,
but you were not.
but I still was next to Christy Morris.
So let me suggest
I was gonna-
Springfield.
going
Walk
through,
through the
I think that was gonna suggest the same thing,
oh,
because I think that's a good idea, because then we can discuss it. As you're here.
Well, in Romanet 2, we get to may injure other property in the vicinity.
Right.
Now, not constrained to physical injury, so you're considering all forms of injury. Black's Law definition does include financial injury as well. Or is dangerous to the health or safety of the public. Subdivision B, grant the authority to control the removal of rubbish, waste, and objectionable material from any premises that is subject to this subdivision. So that means controlling the way that some of this material is removed from a property where there is the compelled cleaning or repair. The context for this portion of the Springfield Charter, when it came up, was discussion around lead abatement and whether simply reaching out to a property owner and saying that you have to abate the property and there's lead there, could the municipality, in this case, the town of Springfield, dictate the way that the property would be cleaned so it's not to cause lead contamination in the process.
did you have?
They do, and that is if there's any type of definition of rubbish, waste, or objectionable material, who gets to determine what is waste, who gets to determine what is objectionable?
So both of the first two terms, rubbish and waste, are defined in Title 24 under rubbish and waste statutes that I can point you to,
That would be lovely.
along with the salvage yard provisions that also exist in Title 24. Objectionable, and that is the phrase that was used in the tree warden statutes as well.
It was used in which statute?
The tree warden.
Okay,
All right, subdivision C, to clean or repair any premises that is subject to this subdivision and recover all expenses incident to the cleaning or repair. expenses that are incurred under the subdivision constitute a lien on the property in the same manner and to the same extent as taxes assessed on the grand list.
So, you know,
So does that mean that if the town forces the cleanup or change of something and assesses the value and the person can't pay it, they could be subject to like a tax sale?
Yes.
Correct. So
Senator Morley.
this bill scares me more and more, Allison, I sorry.
But this is now law in Springfield.
And it shouldn't be.
They're very happy with it.
So like when the local municipals currently Tucker create ordinances, we have like a zoning officer or official. And then most of the penalties are civil. This brings it to a whole different level, am I right in saying that?
I'm so glad that you raised this. So, first of all, set aside bylaws entirely. They're governed by a separate body of law, and have no association with very few exceptions with the police powers exercised in 2291. But you are correct that under 24 VSA section 1971, municipalities must choose whether their ordinances are civil or criminal, or they may not be both.
Right.
Now, under these circumstances, it doesn't seem likely that this would be enforced as a criminal ordinance. But there are, when an ordinance is adopted, if there will be civil penalties that are imposed, a maximum penalty of $800. This is a totally separate piece of authority in that the penalty that could be imposed is the repayment or reimbursement of the costs of repair.
Okay, so Village of Orleans as an example, can tax sale for non-payment of electric, water, wastewater, and now property tax, obviously. And now if this passes this. And would you be then adding the 8% penalty on, or it's
Delinquent, I would have to go back and check the delinquent property tax statutes to see whether the language is expansive enough to include unpaid penalties. Perhaps.
And
Senator Clarkson.
their taxes could be current here. The taxes could be current. They couldn't just,
And they can still sell your home.
well,
no.
I can't do that.
But the taxes could be current here. I mean, this is envisioning a problematic property, which all of our towns deal with. I mean, we all have heard about these kinds of properties. So this is not, don't be so, everyone being so shocked. This is not so shocking. We have lots of properties that are very challenging from a health and safety point of view, from a vermin and garbage and point of view that are vacant. So I think we could do to defining some of these things, because vacant and blighted are both defined, I think, in the VHIP statutes too, aren't they, in the housing statutes? Because we went through this when we created VHIP, Vermont Housing Improvement Program. And it's vacant, blighted, or non-code compliant properties that it applies to, so I think we have those definitions.
I would have to double check on that. I recall that when S-181 was passing through this committee, that both an individual over my left-hand shoulder and perhaps the Vermont Bar Association pointed out that the vacant status is very fungible under the law, and understanding what would constitute a vacancy would have to be very specifically defined in order for it to be consistently and equally enforced. And the question that I remember Jim asking
Right.
on the record was, what happens if the property owner shows up one day before the planned enforcement, turns on the lights for 25 minutes, runs a bandsaw, and leaves? Ooh, is that property no longer vacant? It's an interesting question.
And I think we heard from Attorney Wood, who does the housing proposal, that there is no firm definition of either of those terms.
That is correct, although you currently have a body of law around urban renewal that does include eminent domain proceedings for purposes of abating blighted sections of it. So.
Okay, so I think, again, just to move this along a little bit, line 16, I think we're in.
Yes, All procedures and remedies for the collection of taxes apply prior to incurring any expenses. The town, city, or incorporated village shall adopt the rules governing the compelled cleaning or repair, including provisions for an administrative appeals process and notice pursuant to 32 VSA 5252A3. In order to technically correct a cross-reference in a later subdivision in this section, I unintentionally included other authority that a municipal corporation has. So if you want to look at some of the authority that already exists in law for determining that a building, for example, is uninhabitable and must be repaired, that is in subdivision 24 of the same section. And it has the same authority to force through eventually all the way down the line after many years, potentially the tax sale.
And then there's a cross-reference to, on line 13 on page 3.
That's the cleanup that I was
Okay.
talking about.
Okay, and the effective date. Well, this is not a simple tool.
Oh. But but
I love it. You've had two bills in the last 2 days that I think on this topic have received less than verbose support, but you've
you,
held through and you've made your case. And I think even if we don't take these up, I appreciate that we've done that.
Yeah, no, it's fine. And I'd love to know how Springfield's dealing with it.
I think we need to hear from Springfield. I think we need to hear from VLCT and other cities who want to deal with this problem. And we need to give them tools on how to deal with these properties. It is not fair for other people. So this goes back to a utilitarian point of view. Should one person, or even an abandoned property be able to impact a whole neighborhood, other people's values, other people's health and safety, other people's physical safety? Is that fair? I don't think that helps the common good. I don't think it helps our cities and towns be proud of themselves. I think neighborhoods really, this can be a very corrosive experience for a neighborhood. I have lived it in Springfield because we have so many of these properties in Springfield. We have so many of these properties in Rutland. We have a couple of them in Woodstock. We have them in every one of the towns we represent. And so I think to give towns a tool that they can use, they can choose to adopt this. They don't have to adopt it. We can make it better. But I think we need to give our towns the opportunity to address these properties, which are having such big impact on our neighbors, on the health and safety of our neighborhoods, and on property values in our towns.
Senator Moore.
So hypothetically, I own a building in Springfield and it's not looking like it. And I owe $200,000 on it, mortgage. And they decide, you haven't been, it doesn't look right, or it's dilapidated.
Is less
It's
important.
part of it, the wall might be starting to fall in or something like that. I'm guessing if we put clean it up and the owner doesn't pay, then there's you put a lien on that as well. And then my other question is, if we don't put the lien, we go straight to tax sale. Usually, typically with my experiences, the mortgage company will pay because they don't want to lose title. No,
Right.
is what I think normally happens in my.
You're not.
All of the steps that you just went through sounded accurate. What I will point out is that under that Title 32 process that can end in a tax sale, as soon as you have unpaid taxes at the local level, they constitute a lien. They are deemed by law a lien on the property, and those liens specifically for unpaid taxes take priority.
Yeah.
Right?
Yeah, they're
So,
first out. They're
They're first out, they're first paid. And under the tax sale procedures, there are parties, there are creditors who do not control the amount that the property might be sold for. So there might be, as a result of the sale, unsatisfied subordinated creditors down the line.
Senator Bielski.
I would want to hear from people whose homes have been compelled to be cleaned, and not just from the people who might be offended by the way their home looks, because I am continuing and this was not going to pose a surprise to you, to have deep concern about the impact this has on our growing population of people who cannot afford to do the maintenance that someone in a privileged position thinks they should.
I think you're being caught up on the general appearance piece. This is really about vacant and blighted properties. I would say that it's easy to make fun of the general appearance issue. But I think that the hazardous, vacant, blighted properties are the ones we're talking about. General appearance, I know that sounds like, but most of our towns have design review boards and they're worse. They are worse because they talk about shutters. I mean, I had a whole legal battle in Woodstock about a house that didn't want to put shutters on, and the design review insisted they put shutters on. So there's general appearance. I would say that that is a side issue. I would say that there are some serious issues that affect towns and neighborhoods that are worth considering here. General appearance may, that to me, that's a sort of deflects the importance of what we're really talking about here.
I appreciate that. And I still think that if someone cannot afford the maintenance on their home, yes, if it's going to burn the town down, like let's figure that out. But if someone cannot afford to peel the paint as frequently, or we should not be penalizing them and putting them in a position where they may lose their home.
I don't think that's what this is about. This is about homes that don't have anybody living.
But it will, and if there's a way to draft that we are sure, maybe I could come along to something like that, but there is no definition of vacant. Like, is it, I mean, I'm looking at law now, and under the arson laws, it's vacant if someone's not there. Like,
we can do a better job than that.
I mean, that's very intentionally written that way because the penalty is different if you burn someone's house down with them in it versus not with them in it. But if you look through different aspects of our own law as it comes to housing, we define vacancy very differently. And if we're not defining it for purposes of this bill, do I can say, oh, they're not home today, so I'm going to compel the
Yeah,
it makes
not
you
home
really-
today is not vacant.
It is based in some of our laws.
Not in terms of most of the understanding of the laws that I've been involved in passing like we have. And I think if vacant and blighted are not yet defined, Tucker, we should define them. I think that it's high time, because we have so many other laws that are actually based on vacant, blighted, and non-code compliant.
That's a good.
So I think we could do that with this. I think that it's an opportunity for us to address a very real need in our towns. And we can have the towns come in. I'd love to have Springfield come and talk about how it's rolled out. But we represent 25 towns. I could get probably all 25 of them to come and talk about the properties that they have that they would love to be able to take action on and that they can't.
Okay. I'm getting the sense that the committee would at least be willing to take this up again next week, and maybe I'm misreading the room.
I would urge us to, I think it's a real issue. And if you don't think it is, talk to VLCT. I think that there are a lot of town managers who would love to be able to deal with properties they can't deal with right now. And
Well,
you guys we could go do our homework. I've done the homework. Look, I've got enough towns asked me to put this in. Say, oh, you know what you did in Springfield was really good. We would really appreciate that opportunity.
let me ask you another way. Would there be appetite for changing this in some way to get it to a point where we would be able to at least continue to talk about it? If we took general appearance out, if we modified it in some direction. I mean, if the committee doesn't want to take it up, then we can not take it up, but just.
Okay.
Senator Martin.
Well, I was gonna say, so right now, if I understood from the start of what Tucker said, they can pass an ordinance now to do this, right? Individual towns?
Less authority, but yes, this.
Okay.
No, we would give them.
So, but they could, if one of our towns, let's say I don't know, West Windsor decided they wanted to do this, they could pass an ordinance that's close to this.
Right now, the
Yeah.
municipality could adopt an ordinance to compel the cleaning or repair of any premises that in the judgment of the legislative body is dangerous to the health or safety of the public. And they can establish health and safety standards for premises within the municipality in order to protect the public or prevent physical injury to other properties in the vicinity. That is
Yeah.
the existing store.
So I guess my main
If we
point would
can
be-
just
Oh,
clarify that, because why then, if it's in a charter, so we dealt with this in a charter change.
Yeah.
So what's the difference between the right
Hmm.
to, being able to do an ordinance now and those towns that have charters? So why did we have to deal with this in a charter
Because
versus Springfield just doing it?
Springfield's authority is broader and S 192 is broader. That's of course what is in current law because it is. amended.
That's,
It's not- it's twice.
So everyone,
That was my question. Because this bill is fairly broad and allows the municipality to tighten up. Should they want to with any? Can they tighten it up with this or no? Okay.
well, it gives them,
The local,
It gives them broader
it
authority.
gives them broader authority.
Health clean air repair. It adds
It,
to the scope of properties that could be captured by this authority at the local level.
Senator Mikulski.
I think the current law is sufficient.
Yeah, I guess I would say if we're going, I think we have limited time and we have some other priorities we may want to focus on. And so I think if we're going to hear testimony, I think what I've already heard is it would be weighted. I would love to hear, I too would love to hear from the Vermont League of Cities and Towns and from our local communities and others. But I guess I'm just worried that the cost of doing that to the potential movement of some other priorities. So if we have the availability and time, yes, I'm happy to, especially since this is a Springfield related issue.
Let's,
well, what does John think? What do you think? You're a manager, you're a town manager.
I've never. So as a manager, I would like it because it would help me do certain things. But that being said, I don't want to trample something. I don't want to take away individual private ownership rights either. So currently, we have junk ordinances, you know, where that's defined what junk is, like someone asked earlier. And how many cars can be on the property, but it's everything that we're doing is civil. So I think that we're addressing it to a certain degree. As Tucker said, this is broader, and what the part that I guess that really concerns me most is I've never seen it put in as it becomes a delinquent tax. So if you went in and you cleaned, you did all this stuff, whatever the costs are associated with it,
Passed on to the,
is passed on to the owner.
if there isn't,
Oh, there's always an owner.
well, I mean, or if the owner.
Somebody's owning that problem.
Yeah.
And that's where some of the rub is for me, Allison. I've never quite seen anything like that before.
Well, you live to
Oh, absolutely.
rich the Molly.
Yeah.
No, sure.
okay, one last comment, Senator Mikulski.
Tucker, how many municipalities are using the authority they have now to solve for health or dangerousness?
It's a great question. It sounds like research that I would love to do.
Yeah, I feel like if there's already an authority, perhaps we need to encourage municipalities to use it before we broaden something so much that we're selling people's homes at tax sale that they're too poor to maintain them.
So why don't I suggest this? The committee will meet and decide which path to take, kind of thing.
Mull it over.
Yeah, that's a very good expression, mull it over. If we decide to go forward, it'll probably be next week.
I would ask,
Mhm.
as a committee member, I would ask that we have one more period of testimony with some of the key players and who can answer some of those questions is how is this used? What does VLCT think? And I'd love to hear from the town manager in Springfield. I don't think it has to leave this committee as it is drafted, but it is,
I don't
these are
like,
issues, you know,
Yes,
as a
I don't
town
have-
manager.
I don't have a problem with hearing this testimony
Oh,
from
okay.
VLCT.
So if we gave it just another hour, hour and a half, I would just be delighted to understand both how it's working in Springfield. Is this a problem with our other 251 or 252 towns? I mean, I know it is because I've heard from them, but and see what we could do to make it, I also know there are other members of my housing committee who would love to be able to have eminent domain on houses exactly like this. And that we could exercise, and for me, I'd also love to clarify, why can't we use eminent domain now on problem properties if they are that problematic? But
Would be happy to look into eminent domain for you and probably pass that along to the capable, diligent, and excellent attorney Cameron Wood.
who just happens to have your back.
Somehow I think he knew that.
Some instances you could use eminent domain in
Yes.
these instances. So again, I think maybe our municipalities need to have better.
Yeah, but it's
what opportunities are available to them.
It's very challenging.
Yes.
It's challenging and it's expensive.
Condemnation and
Yeah.
eminent domain proceedings can take a long time.
Yeah.
It's all very litigation.
Lots of bond.
Okay, so more to come.
Yes.
Thank you, Tucker.
Thank you all.
Let's move to our final agenda item, S-196. We had a lot of testimony on this. I think it was Friday.
Another popular bill.
And
Yeah, we put them back to back for you.
we did.
I'm in the 190s. You notice all my bills are in 190s.
Does anyone feel a need to talk to Cameron Wood at all? If not, we can move to the other witnesses, or if you have additional information.
No, sir, I do not at this time, and that would be great because I have to leave you in about 15 minutes.
Okay.
So I just wanted to let.
So let's
Want to come and have
I wanted to be here for as long as I could, but I'm summoned to another committee around that time.
So we're joined by Chris Delia, who's president of the Vermont Bankers Association. We'll hear from Kevin O'Toole, an attorney from Dorset, and we're also going to hear from Vermont Legal Aid on this bill. So Chris, welcome. I think you know everybody.
I do. Good afternoon, Mr. Chairman and committee members. Thank you for the opportunity to come in and testify on S-196. For the record, Chris Delia, President, Vermont Bankers Association, and participant in the study group that worked on property tax sales a couple of years ago. Fascinating discussion on 192. There's a little bit of blending
Yeah.
here, but I'm going to just focus on the property tax sale piece. And I will share with you, my thoughts about what you have in this bill. Number one, I think there would be opposition to going from a year to 6 months on the redemption period. All six of us sitting around this table could come up with a different view of the world on what's vacant, on what's blighted, what's in disrepair, et cetera. That was a big part of the discussion that we had in the working group. And just because I'm in the hospital for 6 months doing rehab doesn't mean that my property is vacant, even though the lights are not on ever. Or I go to Florida or someplace else. It doesn't mean that it's vacant. These were the challenges that our working group discussed and really could not reconcile. So when you're talking about going in a tax sale, and you have to understand how the tax sale works. You go to the tax sale, and the successful bidder is the successful bidder, period. They don't own the property. The people who own the property are the ones that were delinquent on the taxes. It is a policy question, but I would suggest you tread lightly on a policy that allows a municipal entity or a successful bidder to go into a property that somebody is living in to make improvements because it may be exposed to the elements or looks dilapidated. You, as a property owner, I would say, what right do you have to go into my property? Because I may redeem it 10 months from now. And if you go in and you make the improvements to that property, what happens to the cost of the improvements? Well, if there's a mortgage, kind of crossing the lines on 192, when we dealt with it in Springfield, and I'm dealing with it in S696 in GovOps in the House, you're now going to take, whether it's fines or penalties, or whatever the cost is to secure that property, and pick a number. $20,000, $30,000, because it's not clearly defined like we understand property taxes to be. all of a sudden that's sitting in front of a mortgage. I will tell you, we have a problem with the secondary market. I will tell you, even if they bought those mortgages, they will ask the banks to indemnify them associated with those losses. That will have a problem for my lenders. Now, they may say, we'll still make loans out there, but the underwriting's going to change and the cost will change
Right.
for that loan. Springfield is a unique case. I agree with you. Hear from Springfield. But there is no way that I would ever sit in the witness chair and not argue against those fines and penalties sitting in front of a mortgage. Secondary market is used to property taxes. They're used to water, sewer, et cetera. Those are known entities to them. So when I look at 196, I think you've got some real challenges there. One with the redemption period, exposure and deterioration of subjective items that you're going to have to really wrestle with and find consensus on. Ownership of the property, ownership doesn't transfer until that deed is issued to that successful bidder, or it could be the town ultimately because the property owner isn't able to pay off the debt. Blighted vacant, and then again, I've already discussed the priority in front of mortgage. So I understand what you're trying to do because I know Senator Hooker. I've listened to her now in testimony, and I feel sorry for her son, but honestly, you should know that going into the process of a tax bill. This is the way it is. We went from 3 years down to 1. I would guess legal aid's head would explode if we went from 1 year down to 6 months or nothing. I could get to nothing on vacant properties, but when I would argue we'd struggle mightily to find a definition that is going to be acceptable to all parties on vacant properties.
Senator Clarkson?
So Chris, thank you. I appreciate your testimony. I find it a little odd that a mortgage company wouldn't want to make sure that that a property was maintained, because a property that deteriorates is a property that may never pay back what is owed to the bank. So at that point,
Excellent point. Can I respond?
maybe I wasn't quite finished, but I'll
Okay,
go
please
respond right now. Go for it.
No. Please finish. Please finish.
We're only talking about vacant properties, but I'm talking about going in where people are living. We're talking about, they're not living there. Vacant, we are capable of defining vacant. This is not that.
I think that's 192 compared to 196.
It's vacant is vacant. I think that this is one of the things that we would want to ensure that in 196 is that it's assumed, at least I have assumed, that this would be a property that there was no one living in. And I mean, not living in. And it may not even have water hooked up or electricity. I mean, it may, but it's to no one's advantage to have a property deteriorate, least of all the banks.
I wouldn't disagree with you at all. However, let's think about the banks and your initial comment. If a property owner is not delinquent on their mortgage, we as a financial institution have no right to exercise our authority under our documents unless we go to court to do so. No right whatsoever. If they are current on their mortgage. If they are not current on their mortgage, that is a different discussion. So in this case, you're talking about property taxes. What happens in the case of property taxes? I think you alluded to it earlier. If the bank knows that there is a portion of the property taxes or all of the property taxes that are delinquent for a period of time, we will step in and often cure that delinquency, and we will set up a payment plan with the borrower, perhaps escrow or increase escrow, in order to protect our interests in that collateral. If it is a continuation, then we have a problem, but we still can't exercise our authority under the note if they're currently paying the mortgage.
What if they're not paying the mortgage and they're not paying their taxes?
Well, if
I mean, then it's a different story altogether.
if they're not paying, if they're not paying the mortgage, then we have a right to move to foreclosure. We have a robust foreclosure process in Vermont as negotiated by myself and the person to my left, Bruce Basman. And there are steps in place that we have to provide for options of a repayment plan over a certain period of time, notices and everything. They're not paying, we're gonna go through the steps in that process, and if it works out, great. And if it doesn't work out, we're gonna move through the foreclosure process, which on average is 2.5 to 3 years. So that's if they're not paying their mortgage. And again, if they're not paying their property taxes, we will often step in because we want to preserve our interest in that collateral.
Right. I'm clear on what your interest is.
Yes, Senator Bihovsky.
So if the person's paying the mortgage, you have no ability to compel them to clean the property or repair the property. And don't, under the law, if you're the mortgage holder, don't you technically own the property until they paid it all?
Well, the deed is in the property owner's name. So technically they own the property, but we have a lien interest in that property because we provided the funding for them to buy it, but the deed is technically. in their
Okay.
name.
But you have more ownership than a municipality would of that property.
No.
No, okay, I
But-
do not.
Yeah,
We're
it's
this
not,
won't be number one.
In a private home,
if it's for property taxes,
not for property.
Oh.
Okay,
if there's.
I'm confusing the bills. They're too similar. I'm sorry.
Okay. If there's, we have a priority position with our lien in the first place. That is to protect our interest in that collateral and get it repaid in the event something goes wrong. The town has a priority lien if the property taxes or water sewer aren't being paid.
But again, I actually confused the bills because of how similar they are.
Yep.
So the committee that made the recommendations that we were looking at in the report the other day, how many times did that committee meet? What kind of, I'm just trying to get an understanding of the research that went into the decision.
We met,
You served on it, Jim Knapp served on it.
yeah, the gentleman on Zoom served on it, Glade served on it. Senator, I want to say it was probably 4 or 5 times. We had individual committees that took various sections of it. And when the committees reported back and we talked about this particular section, there was a general consensus. I think there was complete consensus, maybe not general, that this was an issue that our recommendation was to look at existing laws and statutes that are at the disposal of municipalities already. I think in particular, one example that we were kind of focusing on was that, to your point in Rutland, there are some properties that are being used for illegal purposes. There's nothing to prevent a municipality today from going in and working with local law enforcement to take action. So our point was, look at your existing statutes to see what authority you have today, rather than going down this road, because this is a very complex discussion to have with many parties that have to come to the table to reach agreement on what do we all mean by vacant? What do we all mean by blighted?
But it sounds like you did pretty significant research and work to come to the conclusion that we shouldn't be doing this.
I would agree. The working group and the representatives on the working group came to that conclusion. And maybe I shouldn't go this far, but I'll go this far by default. The legislature came to that conclusion because the only thing that came out of that study committee was the $1,500 1 year and $1,500 minimum tax delinquency. The rest was not taken up by the legislature. So.
Senator Clarkson.
So what if we actually just change the whole time frame? Because one of the things that's just clearly bizarre is that a buyer buys a property at tax sale, but they don't own it. Why don't we put everything that needs to be resolved ahead of a tax sale? Why do we have this ridiculous system where you buy it but don't own it? That makes no sense to me. Why don't we do all the opportunity for somebody to raise the money and cure their debts ahead of a tax sale? Why can't the tax sale be the last thing that happens
Yeah.
rather than in the middle of the process?
Right.
Because it makes no sense to
So,
be having people go through this no
Yeah.
man's land, as it were,
so if I'm
tax sale.
understanding your thinking, uh, year goes by, I'm delinquent on my property taxes. We go through all of the steps to create a payment plan or help cure. I can't do any of that. And the last step in the process is the tax sale, where after that,
Then you have no right.
there's an
Then it's
immediate
sold.
transfer.
Right.
It's
Why do we not do that?
gosh, whoever set the policy.
Because it's just a ridiculous policy. That if
Well,
you-
I think that's why you're gonna have additional discussions, but I would say that if you're gonna go down that road, there's gonna be a lot of interested parties who are gonna wanna talk about that process to ensure that the homeowner has every opportunity to cure that debt and
Right, so that's in 2
redeem.
years. They have 2 years at the moment to do that.
I hear you, Allison.
No.
I get it, but
So
I'm just saying
why-
that's a very different process than what we have today, and not one that
The process we
that
have today makes no
you
sense.
can do quickly without a lot of discussion.
Right. So I'm just curious why your committee didn't creatively sort of think outside the box and kind of come up with a new system.
We had defined items that we were targeted to look
Oh,
at.
that's never limited in task.
Correct me if I'm wrong, did our committee think about this, what the senator's proposal? I don't
I
recall.
can speak more to it. We do currently have a judicial foreclosure.
Sorry, yeah, identify
process.
yourself.
I'm sorry, Grace Paston from Vermont Legal Aid for the record. And so there are currently 2 different ways in the statutes that towns can foreclose their tax liens or do a tax sale process. One is the one that we're talking about today, which is, in my experience, the one that 100% of towns use, which is a faster process. There is no judicial oversight or due process rights other than some notices that have to be mailed to the homeowners. And the other process is one that we think is much more protective of homeowners and their constitutional rights, which is what Mr. Delia's members have to do when a mortgage isn't paid, which is to start a judicial foreclosure process. And in that process, you have due process rights, you have court oversight. And once you get a court decision and you get a final judgment of foreclosure, there's a pre-sale redemption period of 6 months. And at the end of that process, what is sold at auction is the property rights. And that is how many, many states conduct their tax sale processes. So I certainly, from Vermont Legal Aid's perspective, would 100% be in favor of using that judicial tax lien foreclosure process, because I think it strikes the balance between protecting homeowner rights, but also, rather than selling this sort of intangible, selling the tax lien, when you get to the sale, you're actually selling the property rights. So that is another model. And that is already on our statute books. The reason it is not used is because there are additional expenses to the municipalities, is my guess. And, there's additional process that's
It's so much cleaner.
So
It's just a
wait.
cleaner process.
Municipalities can already do exactly what you were just saying.
correct. They have to wait 2 years for that tax lien to mature to a point that they are statutorily allowed to start the foreclosure sale process. But yes, every municipality in the state currently has that opportunity to use that.
Then why don't we just get rid of the tax sale process and make municipalities do that?
I think that would make much more sense.
Like, we need to get rid of this whole
Yeah.
tax sale process.
I want to at least
Can I-
get.
Can I speak? I have an appointment at 3:15
Okay.
and I
why don't
thought
you
I
hear-
was coming on at 2:30.
No, go ahead.
With all due respect to Grace and Chris, if I could just speak for a little bit about this S96, okay?
Yeah.
196. First, as to the first question about whether a bidder should be allowed early access, I submitted as as an exhibit, a section of the working group's report, of which
Yep.
Chris was a member and Grace was a member. Okay? And on this particular point, we were unanimous because it was unclear of whether something, was deteriorating. It was also quite clear that third party, even a high bidder does not have an insurable interest at all. So if they come on the property, they're not being insured at all. And let's just say it's been abandoned because somebody has died and the family is trying to struggle to agree to have an estate probated. Okay? So suddenly, and they put it up for sale, you're going to have a third party go on a property that you can't control and interfere with the sale process. It just, so we had several things. Also, illegal activity, there are other avenues available. You can call the police. There are other avenues. If it's deteriorated, you can condemn the property. There's already legal avenues for that. So our committee was, and I think it was myself and Grace Pasden, and there was a subgroup, but we were unanimous on this point, that it was just too complicated to deal with. And the existing 1 year had worked quite well. And I tell people at a tax sale, you don't have the right to go on the property. You have the right to have interest on your bid, period, during the year. Because let's just say that a bidder had this right and went on and started making improvements and somebody redeems. Well, now the person can kick them off. And that bidder is out of luck. I mean, they've made improvements. They're not going to get reimbursed. And Lord knows what they've done because the bidder can't control what they're doing. It's just really a mess and one you really don't want to step into. As far as the second part of reducing the redemption period to 6 months, as it is, after the year redemption period, if the IRS is involved, they have an exclusive 120 days after that so 6 months would be within that, but it would give you very, very little leeway. Okay. Also, in the 6 months right now, one of the best things that Grace pushed for, and I bucked on it, but it's been great, is that you have to send out a certified reminder letter between 90 days and 120 days from the end of the redemption period. You reduce this to 6 months, you're sending it out within 2 months of the sale. So let's just say that you've been behind on your taxes and you just couldn't get it together. You couldn't get a payment plan and it went to tax sale. You're trying your relatives, you're trying everything to get it. Finally, you'd say, I'm going to have to put the property up for sale. 6 months may not be enough time to do that. Certainly not if they have to probate an estate in order to be able to sell the property. I've been doing this since 1988. The 1 year redemption period has been there at least since then, and it has worked. Furthermore, tax sales are under attack. I cannot imagine that if you lower the redemption period to 6 months, you're giving them ammunition to attack tax sales altogether. Furthermore, who are we serving? Who are we trying to benefit? The municipalities just want to collect their taxes, period. If they have a tax sale, they've got their money. So the rest is just up to the bidders. Are we trying to serve these bidders? Are we trying to ultimately help people who might lose their homes?
Or people
Bidders are making interest on their money. They're getting 12%. They're doing just fine. But that's not who we should be looking out for. The last legislature went out of its way to make a $1,500 minimum, to say we had to wait for a year because we were concerned about people who might lose their homes. I think that's where with all due respect, that's where the focus should be. Now the year is a firm deadline. And when people are under tax sale, the first discussion we have with them is you have a year to work this out, but you only have a year. 6 months sounds an awful lot different, and I would be very much opposed to that. Our working group did talk entirely about the first subject, and that's in the report that I submitted as an exhibit.
Yep.
The second, we didn't discuss, but I would be opposed to. And I think that Ms. Pasden would certainly agree that we were on board together on that. And I think that she would be opposed to lengthening it from 6 months.
Okay, we're gonna hear from Grace in a minute. Senator Clarkson.
Kevin, could you just identify who you are for the record and what your experience is? What do you serve? Do you come to this committee as a lawyer, as a manager? I'm unclear
On
what
the
you're.
working group, I represented the Vermont League of Cities and Towns. I'm an attorney who's helped municipalities conduct tax sales since 1988. Okay?
Wow.
Right now, I'm representing 5 different towns doing tax sales. We hear stories all the time. And we try to be as compassionate as we can because these are all individuals with individual cases. And the case I said about, one, the parent died, the 2 brothers have to probate an estate in order to sell it. That's going to take time. Okay.
So can I
So
just
that's the
follow up?
point of
We have
view I'm
7 more
taking.
minutes before you have to leave us. I don't think you should disparage bidders because they are people trying to afford a house at a rate that they can actually afford it. So there are a lot of people with, we have a housing crisis. So people are trying to do things affordably. What do you think of Grace's idea of I think what I would love to do is really go back to the system that Grace says exists in law, where we have, before you even have a tax sale, you have exercised all the opportunities for people to cure their debts and to actually maintain ownership of the house.
Well,
Strikes
first,
me.
let's just back up to people. If people want to buy a house, they're not going to use a tax sale because they can always redeem it.
That's not the case. I know plenty of people who go and try and buy a house at tax sale, who can't afford a house in Woodstock, for example, at an average price of $800,000. So no, I don't agree with you. I think there are people who are actually trying to buy houses and renovate them and fix them up. So anyway, we can argue about that. But what my question is, don't you think it would serve everyone better if we finish all the work of curing a tax debt before we enter a tax sale? And then, as Grace has suggested, there is an opportunity in statute for us to choose so that we don't have this limbo, this crazy land of somebody thinking they've bought something, but actually not owning it for a whole year.
Okay, first, when I have a tax sale, I make it quite clear to people before the tax sale, during the 1-year period, all they have is a bid, the right to have interest, and that they don't have the right to go on the property. Okay, that's made crystal clear to them. It's also made clear to them that if the year goes by, they're going to get a tax deed and also probably a delinquent tax bill for the year that just went through. Okay, so I make that clear to them. I'm going to say 80% of all tax sales I do are redeemed. Okay, so if you want to go buy a house, this is not the way to do it. This is just not the way to do it. Once in a while, we have a situation where we know it's going to be lost. Maybe it's vacant land. Maybe it's an estate and the person's died and no one's opened an estate for years. So sometimes we do know it's going to be lost, but it's something like 80% are redeemed. So I think that the job that the legislature should try to further is a tax sale's point is to collect taxes. Okay. If you have a tax sale, you do that. We should, the bidders have an incentive. They're making a percent a month on the bid. So if you bid 10,000 at a tax sale and it's 1% a month, say you bid 100,000, you're going to make 1,000 a month. Okay. You're doing fine. You're doing fine. That's 10%. It's not 12%, but a percent a month you're getting. So that's what many of our bidders, they don't want the properties. They're just chasing the interest. Okay.
I haven't answered my question, which is, what would you think of using Grace's idea of completing the entire process before you even enter into a tax sale? So there is not this period of uncertainty for anybody.
Our working group did actually invite Grace to have somebody from Maine talk to us about a different system. And at that time, we did not agree on adopting that and went back to just curing the existing statute. I think that's just a larger discussion. But I would say that if you want to cure a housing problem, don't use a tax sale statute to do it. don't try to make some end run. Try to, it's a square, it's a round peg in a square in a hole. It doesn't work. But I will say that in some close to 40 years of doing this, we work with people all the time to try to make sure that they're not going to lose their homes and pay the taxes. Sometimes it doesn't. It seems like my appointment is knocking through the door, but.
All right, and I apologize. I wish our legislative time ran on the sort of schedule you might be able to adhere to, but it doesn't. So that's why we didn't take it up right at 2:30 because the bill before we got caught up. And so,
Oh, no,
Thank you.
things happen, but
yeah,
I
okay,
just learned about it on Friday. So,
yeah. Thank you, Kevin. I appreciate it.
Okay. All right. Thank you very
Take
much.
care. You bet. So our final witness is indeed with us, and please join us at the table. This is Grace Pasden from the Vermont Legal Aid, and she also submitted written testimony. But if you want to just read that, or however you want to express your own feeling on this.
Thank you. And thank you for having me today to talk about S196. For the record, Grace Pasden. I'm currently the director of the Consumer and Homeowner Rights Project at Vermont Legal Aid. I've been an attorney there for 17 years. During all of that time, I have worked with low income, disabled and older homeowners, both defending against foreclosures and property tax sales. And as you heard from Chris and Kevin, I was also very involved in Act 106 and on the Act 106 working group, which considered a lot of these issues that we're talking about today. It is one of these rare, beautiful unicorn moments where we all agree on these topics. And I jotted down when I was told that I would have the opportunity to address you today. I jotted down many, many notes about the various sections in this bill. And I'm going to be able to consolidate my comments because these folks before me have already testified to a lot of what I would have said. But I guess just the overarching thing that I would like folks to understand from the perspective of someone who works with people who are struggling to keep up with their delinquent taxes and who are finding themselves in tax sale process is that primarily what we see is that folks are not able to access their homestead property tax credits. So these are fixed income folks, older Vermonters who are on Social Security retirement benefits, disabled Vermonters who are getting disability benefits. They don't interact with the income tax filing system. And our homestead property tax credits program is tied to filing forms with the tax department every April at income tax time. And folks don't know how to access that process. They often miss out on tax credits. I mean, really life-saving tax credits that mean that they can both pay their taxes and put food on their table. And so that spirals to a point where people fall way behind on property taxes that they shouldn't have owed in the first instance because their tax credit would have covered most of that. And I can tell you, I've never interacted with a homeowner who hasn't paid their taxes because they didn't want to or they weren't prioritizing it. It's either this situation I'm telling you about, or it's some kind of catastrophic illness, medical issue, loss of a spouse or other household income earner. It's always some kind of financial crisis that is leading people to this place. And folks really need that 1 year period to figure out a way to come up with the funds, which tend to be pretty significant. They include 12% interest that this tax sale bidder is making over the course of that redemption period. And, folks are often waiting on a tax refund to get paid up. They're trying to take a loan against the equity of their home to pay it off. They're, trying to set aside funds and pull together borrowed funds from friends and family. So cutting that, what is fairly short to begin with, from our perspective, and some states are at 3 years, Vermont's at 1 year post-sale, would be really, really harmful to people's ability to save their properties.
Senator Bielski.
I'm just trying to, I really appreciate your testimony. I'm just trying to understand, are there states that don't do this tax sale process at all and just do the sort of judicial process that you were talking about?
Yes. And I will tell you, I have not looked at every state's statute, but it is a state by state analysis. every state does this a little bit differently. And some are selling the property through a judicial process, and some are selling a tax lien certificate closer to what most municipalities do in Vermont. What is unique, I think, about Vermont is that municipalities already do have this statutory authority to go through the same judicial foreclosure process that mortgage lenders use, but we have never seen that. And historically, it just has always been this non-judicial, we give notice, we do a public auction of the lien. That sits for a year while the person has that year to redeem. And then at the end of it, title just gets transferred by the tax collector. One thing that I think I can add to this discussion that may be the very best reason for this committee not to act on this bill is that there is currently pending before the United States Supreme Court an appeal that they are hearing next week. They're hearing oral argument on next week. It's called Kung v. Isabella County. It's a case out of Michigan where the Sixth Circuit held essentially that it was constitutional and did not violate the takings clause or the excessive fines clause of the Constitution for the municipality to take a property at tax sale, sell it to a third party for some amount less than what the property was valued, so long as they handed over the proceeds, the surplus, over to the homeowner. The homeowner has now appealed, and the United States Supreme Court saw fit to grant cert to hear this appeal, and will now be taking up the question of, is it an unconstitutional taking or an unconstitutional excessive fine for the town to take a property for something less than the actual value of the property? And in Vermont, I will tell you that if that case goes, frankly, the way that for our constituents, we hope it will go, that will mean that the current tax sale procedure that we have on our law books could very well be unconstitutional, and we will need a whole-scale revamping of our statutory tax sale process. So I would suggest, since that decision is probably going to hit this summer based on how the Supreme Court operates, that this committee hold off on making any tax sale policy changes this session, because we're going to know a lot more about what the constitutional confines of tax sale process are, and that's a better position from which to make tax sale policy.
Seems really reasonable. My other question for you, and you may not have the answer, the data may not exist, but one of the data points we've now heard twice is that 80% of people whose homes are sold at tax sale redeem within the year. Do you have a sense of when within that year is sort of the average?
I mean, I can't say that I have enough, I think, of a pool to give you really good statewide data on that, but I will say that I've personally worked with at least a handful of homeowners who weren't able to redeem until sort of the last couple of months of the process. And that's because they're applying for a reverse mortgage so that they can take, they can access equity from their property to pay off the debt. It's because they're trying to pull together funds from where they can find them. They're waiting for tax season because they know they're going to qualify for a tax refund. So I absolutely think that a year is not only reasonable and sort of minimally necessary. I think if you look at other states and how their process works, I think a year is a pretty average amount of time. There are a few outliers that have 6 months, but there are also a lot of states that have like a 3-year post-sale redemption period. So I would personally be very uncomfortable with anything less than the year.
But your experience is that once someone has the money, they pay it. They're not waiting until day 364 just because they can.
Oh, absolutely. Yeah, folks are absolutely paying as soon as they can. I mean, it is challenging because you have to remember that not only is it the delinquent tax, with every month, right, there's an additional 1% interest that's accruing on that debt, plus you're paying all of the fees and costs associated with that tax sale process. So once you get to that tax sale, you're really talking about things increasing quite a bit. And then in terms of, what other folks have already discussed in terms of the bidder being able to go onto the property, I mean, I really think, as others have said, I think there are some real like liability concerns there. I think, you know, homeowners aren't even entitled to a report of sale from the tax sale. So you might not even know that somebody has whatever amorphous interest they have in your home when they purchase your tax lien bid. And now this person might be storming onto your property because they think it's deteriorating. I mean, people have guns across the state. This could be a law enforcement like liability issue. I just think there are a lot of potential scary implications of allowing folks who don't have a title interest in the property to sort of come on and, you know, potentially change locks or, you know, make improvements to the property, particularly when you hear that, you know, 80% of the time, the original homeowner is going to retain the homeownership rights at the end of the day. And then where does that leave everybody's interest at the end of the process?
Senator Clarkson.
Grace, I get
Yes.
all your points well, and I think they're terrific. I really am intrigued with or without the Supreme Court, because I have mixed feelings about what they're capable of anyway, at the moment. But I think your original proposal to us is great, because I think going to what are we calling a judicial judgment?
Judicial foreclosure. Yeah,
Judicial
tax lien
foreclosure.
foreclosure.
It's so much cleaner. It just makes so much more sense. I think this, I mean, even though it saves the municipality money, the 12% interest alone is the reason not to have done it. I don't understand why we got ourselves into this very messy, awkward opportunity. I mean, I would much rather see a clean system of giving people adequate time to cure the debt and the lien. And then they have a real tax sale. I mean, then have a real sale other than a tax sale if they're not able to do it. It just makes so much more sense. I really think that one of the things I balk at is that this is just a messy process that families, I mean, for most people, because we have experience around the table that where people are speaking from experience, having gone through this, it's just such a challenge for family, for those who are living in the house. I mean, I think that the fixing the house up and protecting it from the elements is more for vacant homes, not for houses that are occupied. And it was never intended for occupied houses. But I think your judicial, the judicial process makes so much more sense. I don't know how we ever got here.
I don't think it would be hard to move in that direction. It would really be about removing the ability to just file a warrant in the land records and do the tax sale after notice. I still would caution the committee to wait to see what the state Supreme Court tells us, because even with the judicial foreclosure process, there is a world in which the Supreme Court says, even at the end of a judicial foreclosure process, when the property is sold at foreclosure auction, it has to be sold for a certain percentage of the value of the property, right? Because the question is about people not losing their equity, the municipality not taking the equity from their home. So I think we're going to learn a lot when that decision comes out. And if, you know, this committee or the legislature in general wants to take a look at tax sale policy, I think the moment to do that
Is
after that
it's
decision. Hung v. Isabella County. And I did, in the email I sent to the committee earlier, I sent the link to the Supreme Court docket.
Right.
So that you can learn more.
So it's in your testimony. Oh, right.
Okay.
I think I'm okay for today.
Okay, thank you. And I will just say, I was here for S-192. I just became aware of that earlier today. I had some very big concerns about that and the provisions in S-196 around increasing and expanding municipalities' authority to make repairs on commanded properties. Again, I think this is going to implicate really complicated constitutional Fourth Amendment search and seizure issues, takings issues. I mean, there is this police power that, you know, government, entities have, but it's really around like imminent risks to safety and help. And this starts to get really squishy in terms of allowing municipalities to come onto properties for a whole host of potential issues that really aren't about imminent harm to the community and to the public.
It's meant to be about harm to, it's meant to be about harm. I think we can, yes. Anyway, we will hear from Springfield.
I thought you were all set.
I think there's a difference between harm and imminent harm. I think that is a critical point. I do have so I'm zooming back to tax sale for a moment because it's sort of a larger question of like how, if there are things we could do or change
Yeah.
to help prevent people from getting into those positions. Because one of the challenges, I mean, I don't know this personally because I can't afford to own a home in Vermont. But one of the challenges I hear about is the sort of that year. So something really big happens. I retire, I lose a spouse, and my taxes that year are going to be on last year's income.
Right.
And so that retrospective can
Right.
put, whereas
Yes.
if we moved to an income tax or we moved to something that was more immediately responsive to income changes, if that would decrease the number of people that ever found themselves in a position of having to go to tax.
Yeah, I think that is one problem that's affecting particularly a lot of folks in towns that have recently reassessed, where the value has jumped way up, but you're still doing this 1 year look back, and it's creating a situation where people's credits aren't really filling that gap. But that's for the people who have figured out how to access that income tax credit. So I think that's the biggest issue. And I know I've talked to the tax department. I think the legislature has gone back and forth over the decades around whether you sort of opt into the homestead and you stay in the homestead and you get your credits, or whether you have to refile every year. I think this filing every year and not having a retroactive ability to go back and file retroactively if you missed it is really hurting the lowest income, most vulnerable homeowners who really need those tax credits. And that's who we talk to
Have
every
you
day.
testified to Ways and Means about it?
I have testified to Ways and Means, but within the context of that Act 106 bill, which sort of addressed a bunch of issues. And so I can't say that any committee has fully sort of looked at or taken up the issue of the tax credits. And I think it is thorny. A lot of other states sort of do it they have county infrastructure, and their tax credits or tax exemptions are dealt with like at the county level, right? So you would have to figure out a system that could work in Vermont, but like most of these poor homeowners are not interacting with the tax department, and they're just missing it. They don't know to file. They don't know how to get that tax credit. They don't even know it exists. And so they're paying thousands of dollars more in property taxes per year than they should based on their income. So it's great because we have a very progressive tax credit policy on the books, but like anything else, to some extent, it's window dressing unless people can actually access it. And my family for many years when we qualified accessed it, right? I'm an attorney and I'm at the our household was at the upper end of that, and I could figure out how to get those forms filed, but I didn't need it. I wouldn't have lost my home had I not gotten it. But those clients who really aren't going to be able to hang on to their property without those credits are the ones who are, very rarely going to be able to access it.
Thanks. It's really helpful. So whenever I know that that's not what we're talking about here, but it to me sort of identified an upstream. Like we can argue all day long about how the tax sale should happen, but I think it's almost more important to prevent someone from ever getting to the point of tax sale. So thank you for indulging me
Very
on
welcome.
that.
And if there's anything I can do to help this committee or anyone in this building sort of
We have
find a path forward on that issue.
But we have actually in the Office of Administration, we actually have somebody who's responsible for communicating to the public. Rebecca Kelly, I can't remember the name of her office that she's director of, but she's director of this piece of communication. I cannot believe that we need to communicate this opportunity, and particularly if we keep it, depending on what happens with inflation, property tax. But if we keep it, if there are that many people who are not filing for their homestead declaration, and therefore not being able to access their income sensitivity. That is shocking. I don't, I go door to door to every home when I was a house member, and very few people didn't access that, particularly in Woodstock, because they, it was too valuable to not access it. So I don't
I mean, we
know how
work with a
those people
lot
are
of
not being
disabled
reached.
clients. We
Yeah.
work with a lot of people with challenges and like, I mean, I will tell you, it's a very complicated form too. So we have that problem too, where we have folks who will file and don't end up getting their credit.
Well, but there are plenty of people out there to help them too. So there is help there in our.
Senator White,
Thank you, Mr. Chair. Yeah, so I serve on the Board of Abatement for the town of Hartford, and that was the complete difference between
Yeah.
previous years and the most recent 2 years, was folks who had never previously filed their taxes. Well, they had, but then they were retired, and so they were
Right.
stopped filing
Yeah.
their income tax. And so then they thought, oh, well, I can just go back and I can get that money, and then they can't. And it
Right.
really surprised me.
Yeah.
Some folks were able to take advantage of some federal support that had been available during COVID, I guess.
We have, yeah,
Yeah, but
that's
we,
long
we
gone.
ended up,
Right?
yeah,
Yeah.
what we ended up seeing was we were just evading people's taxes because we just thought they are owing taxes that they should not be owing. Therefore, we as the town will take on the burden of the That's what, at least in our,
Well, thank you for
This is-
doing that.
we abated so many of those situations. And I know I had heard in other towns, like they weren't abating those instances, which was very surprising to me. So I do think we need to address it. And I would also just ponder, it concerns me that you have no ability to even go back to 1 year with the homestead tax exemption, because what we found were folks who were almost within like a month of filing, like missing the deadline by a month. And they were still owing thousands of dollars that they had not anticipated, because the timing of when the change in their property value happened and the time and the change
Right.
of when they would have needed to file were not the same. Like the alert of I'm gonna have to pay more money came after the deadline to file your taxes, where you maybe even had pondered, do I really want to actually file my taxes? I only get what, $100
Right.
off anyway. Well, no, you actually would have gotten like $3,000 off, but because you didn't have that alert, basically, that you were, yeah, it was very shocking to see.
Yeah, it's
And
very
we may not
shocking.
see it door to door, but we see it at the abatement hearings. And so I do support this. And I would
I
just say,
appreciate you for your service, and I
you're
appreciate that, that your town is abating. I mean, that is another area where we have tried to get some movement, because that's an entirely discretionary process. And so we find from one side of a town border to another, this Board of Abatement may just, always say no, regardless of how sympathetic the circumstances are, or what the basis for the request is. And it might be due to no fault of their own, right? Someone did get a credit, and yet that town just has a process where they're always going to say no to
Yeah.
abatement. And then on the other side of the border, you could have a really great, Board of Abatement that is really looking at the case by case facts and abating where it's appropriate. So certainly tightening up abatement and creating some criteria under which boards should abate could be really helpful.
And we made some changes last time because of Hartford, I would argue, because we were having trouble with abatement of water and sewer issues where we were technically outside of the law. And so it was
Right.
nice to get like the official cleanup. But I do wish there was a way, like we have a checklist of what do you qualify in the statute to actually mean that you should get an abatement. And I wish there was a way to say like other taxes are the reason, like, oh, like debt to the state or federal tax. Yeah, I mean, you don't have a federal property tax, but you know what I'm saying? Like,
Yeah.
if there was another way to frame it, because there is a difference between not having enough income or having a catastrophic life event and then having other tax related problems affecting your property tax. So
Absolutely.
I have a lot of thoughts on that. But
okay.
yeah.
Thank you
Well,
very much, Grace, for your testimony. We
thanks.
appreciate you taking time today to
Thank you.
join us.
Appreciate it.
And that will conclude our look at what we had up for discussion today. Tomorrow, we're going to do the two charters that we don't have enough information on, Burlington and Essex. And So we will go off for the day and